Hello, this is Steve Rinka from the Rinka Law Firm, and I'm here today to talk about the Case Management Conference. Now, after you file the lawsuit in California, in particular in Los Angeles County Superior Court, the court will either give you a notice of a case management conference hearing date at the time that you file your lawsuit, or the court will sometimes send out notice a week or two after you've been assigned a judge. One way or the other, you will have a case management conference with your presiding judge. Typically, it'll be, 3-4 months after you file the lawsuit. The purpose of the case management conference is to set forth the facts before the judge, to familiarize the judge with the lawsuit, find out what discovery has been conducted to this point, as well as set forth a trial date and final status conference date. Now, you will find that not all judges handle a case management conference the same. As mentioned, many times, most of the time, the judge will set a trial date. However, some judges, what they will do is they'll come in, have you sit down, talk about the case, talk about the facts, what needs to be proved, what discovery, subpoenas need to be issued, depositions that need to be taken. And instead of setting forth the trial date on that initial case management conference, the judge will have you come back in 3, 4, 5 months later to find out what has been done, determine whether or not it's appropriate to set forth the trial date. If not, the judge will set forth a further status conference, at which time he will likely or she will likely set forth the trial date. Typically, a case is set for trial within 1 year, maybe a little more than 1 year after the case has been filed. And I'm talking more particularly with respect to unlimited cases. An unlimited case is a case that's valued at $25,000 or more. These types of cases, usually the court allows a little over a year in order to do all the discovery and prepare for trial. Now, before the case management conference, you will need to file a case management statement. A case management statement is a form statement. You can get it on the internet. Just Google California court forms. The court form number is CM-110. It looks somewhat like this. This is just a blank copy. It consists of 5 pages. And in this document, you're going to set forth your name as the representative if you're representing yourself, or the attorney who should file this on your behalf will put forth their information, as well as the date of the case management conference, the date that the complaint was filed if you're filing this as a plaintiff. What this does is this form gives the court some information about your case before you appear before the judge. This way it helps save a little time at the case management conference hearing. Some case management conference hearings can last, I've been in one where it lasted 45 minutes. Others will last maybe 2, 3, 4, 5 minutes. Every judge treats their case management conferences differently. So you never know what to expect unless you are familiar with the judge who you're going before. You may be surprised as to how quickly the case management conference lasts. The other thing it does is it asks for a brief description of the case, whether or not you're requesting a jury trial. It's also important to remember you have to pay jury fees at either the date of the hearing or prior to that. If you pay after, you could potentially waive your right to a jury. So it's important that you pay your jury fees prior to the case management conference. The jury fees are $150 per side. It asks for you to set forth the estimated length of trial, who will be representing the party that's filing the case management statement at trial. If it's going to be yourself, you put yourself down. If you have an attorney, you put the attorney down that'll be representing you. Then the form further asks what types of mediation services you're willing to engage in. If it's a mediation settlement conference, typically a court will set forth the settlement conference. The court in all likelihood, most cases, they want the case to settle. They don't want to try the case because it is costly, timely. In most cases, if they're well litigated, both sides know each other's side and they can be resolved without having to go to trial. But you never want to assume your case is going to go to or going to resolve at mediation, so you have to assume your case is going to go to trial. And then with respect to the defendants, there is a question whether or not there is insurance involved that would be paying out any sort of judgment or settlement. If there are any related cases, sometimes you will have a situation where you have an accident and there are multiple parties in the accident, and you have one set of parties that file a lawsuit, another set of parties that file a separate lawsuit, but they all arrive out of the same traffic accident. So what the court will do, they will consolidate those causes of action or those lawsuits because it's more efficient. Plus, it prevents a contradictory outcome, because if you're having the same accident, naturally the facts should be the same, so the outcome of any resolution should be the same. But if you have two separate causes of two separate lawsuits, you can have a situation where you have two separate and different outcomes. Then they also ask how much discovery that you are going to need to do, such as written discovery, depositions. If there's any sort of issue that might arrive relating to discovery, such as the availability of a witness, having to travel out of state, things of that nature that might require a little additional time to get the case ready for trial. Then there's also a section that asks the parties to set forth if there's any issue the parties want the court to address at the case management conference. This can be the availability of a witness, if there's going to be a protective order, certain issues that the parties know are going to come up in the litigation, and they want to give the court a heads up, and the court might give some guidance as to how to avoid or how to resolve the potential conflict. And then also the parties are required to meet and confer prior to filing the case management statement. There is a section verifying that the parties did in fact meet and confer. So this has to be filed, the case management statement, 15 days before the case management conference. And it must be served on all other parties. That's all plaintiffs and all defendants. So once you have filed your case management statement, there's not much left to do except wait for the case management conference hearing date. You will go down there on the date, go before the judge. Depending on the judge, as mentioned, they will ask you various questions relating to the case, the status, and in all likelihood, they will be setting forth the trial date. It's very important to understand that the trial date the court says is typically a hard date. You will only be able to get that date removed or changed if you have very good cause. Most judges, once they set the trial date, they put it in their calendar. That's the date that's etched in stone to a certain degree, and so in order to get that date changed, you better have good cause. Otherwise, plan on going to trial on that date. And the trial date is the date that all other pre-trial deadlines will be based on. So if you have any further questions regarding the case management conference, please feel free to contact me, Steve Rinka, at 310-556-9653. Thank you.